Hello, everyone. This is Michael Kupfer with Harvard Business Services, and thank you for joining us for today's webinar. Our topic is corporation basics, and our presenters today will be Jared Melson, our General Counsel here at Harvard Business Services, and Brett Melson, who happens to be his brother, and the Vice President of Sales. I will let them introduce themselves in just one moment. A couple of quick notes before we jump in. We will be running roughly an hour. We're going to try to get everything in. We got a lot to get to, so it might run a little bit over, hopefully not. And we will also have some time whenever that presentation is done for question and answers from the audience. So if you have questions, you're welcome to send them in as we're going along, and we'll answer what we can. Anything else we will get to at the end of the presentation and make sure you get an answer to your question. We are recording the webinar today, so tomorrow you should be receiving an email that has a link to the recording as well as a copy of the slides that we're using in a PDF format. So you'll have all of that to go and review if you need to. Eventually we will also have a transcript of the webinar up on the site that usually takes a little bit longer to polish up. And so let me jump to the next slide here. A little bit about us as a company. Harvard Business Services was founded in 1981 in Wilmington, Delaware, by Rick Bell. Rick and his son Michael, who is the new president of the company, can be seen in the photo to the side right there. This is a family-owned and operated company. We're headquartered in Lewis, Delaware. We have a team of about 40 people. We're all working out of this office right along Route 1 in Lewis. We've formed over 225,000 companies and have over 100,000 current clients worldwide. So we're helping entrepreneurs all over the world incorporate and get registered agent service for the state of Delaware. We are a Delaware registered agent and formation specialist. We're a very customer-focused company. We have the highest customer service ratings in our industry. You can take a look at trustpilot.com and look us up there, and you'll see all the feedback that we're getting from our clients. And just a couple of disclaimers here at the end. We're not attorneys or accountants, although Jared is an attorney, but as a company, we're not attorneys or accountants. So please don't take anything that we say as actual legal advice or accounting advice. You should seek your own attorney or accountant for that information. And we have no affiliation with Harvard University. We share nothing but the name Harvard, the word Harvard in our name. And that being said, we have just a few agenda items that we're going to cover in today's presentation. Key elements of the corporate form, the governing documents of corporations, some fundamental terminology or fundamental terms, overview of fiduciary duties, and a brief comparison to public benefit corporations. And Brett and Jared are going to get to all of that, so I'm going to turn things over to them, let them introduce themselves, and get started with the presentation.
All right, good afternoon, everyone. I'm Jared Melson. Sitting next to me is Brett Melson.
Hello, everyone.
We're both, as Mike mentioned, I'm the General Counsel of Harvard Business Services, and Brett is the Vice President and Head of Global Sales. Today, our goal is really to give you an overview of the corporation as an entity, what is it, and secondly, some key terms, trying to give you familiarity with some basic things you're going to hear about in forming a company, things you'll hear about in getting advice and researching what a corporation is and how it operates.
So we'll go ahead and start with why do clients go ahead and incorporate in Delaware? The biggest and the main reason is the sophisticated law structure. This Delaware corporate law structure, general corporation law, was enacted all the way back in 1899. So it's got quite a bit of history that goes behind it.
That's right, Brett. The legislature is advised by very preeminent corporate lawyers, and they're very receptive to that advice. And as such, Delaware tends to be not only a stable, solid place where new laws are passed, it's also a place of experimentation where, the Delaware is pushing the boundaries on incorporating fintech into the corporate structures and corporate operations. It's got a blockchain initiative currently underway to incorporate blockchain technology into share ledgers. So it's as strong as it has been traditionally, but yet it's pushing the boundaries simultaneously. In addition to the statutory law, you have a large body of case law in Delaware. Over the years, very sophisticated jurists from the Chancery Court, which is our specialized business entity court here in Delaware, have developed a huge body of case law in virtually every element of the operation and governance of a corporation. This body of case law grants people forming in Delaware a predictability and the ability to structure their terms with certainty, or at least some certainty, that they know what is permissible. You've got so many examples from the cases that you can draw upon that it really helps to guide your actions and those of attorneys in structuring and operating corporations.
Jared, you mentioned the case law in Delaware. One thing that we should point out as well is the importance of the Chancery Court. Mm-hmm. Not just the importance of the Chancery Court, but a little bit about who's behind this Chancery Court, the actual individuals that are appointed to the court itself.
The Chancery Court judges, I mean, all of Delaware's jurists are very experienced in corporate law and the law of business entities, all the way up to the Supreme Court. But the chancellors in particular are preeminent corporate attorneys, generally sourced from Delaware, from some of the largest global firms in the world, but people with immense, deep, and rich experience in everything regarding corporations, from litigating these kinds of disputes in the Chancery Court to transactional work and structuring the corporations and their businesses.
So they've got a wealth of knowledge that they bring to the court, so it's not being presided over by people that might not have the knowledge involved for some of the complexities involved with the cases that are brought forth.
That's right. In some of the other states that are trying to make themselves corporate domiciles, you see someone who might be handling a ordinary business dispute, a judge that might be handling a business dispute, suddenly handling a fiduciary duty case with very little background or context or the sort of richness of experience that the Chancery Court judges would have. Now, again, one of Delaware's key advantages is it's not only business friendly, but it also has a great deal of investor protections built into it. It's a proper balance between a pro-business environment and investor protection. Possibly the key way that you can see the pro-business side is the business judgment rule, which is in looking at a corporate dispute, in the dispute governing the internal governance of a corporation, the judges of the Chancery Court assume that the corporate officers and directors have acted in conformity with their fiduciary duties until that assumption is reversed by evidence presented by the plaintiffs, the shareholders oftentimes. They have to make what's called a prima facie case overturning this presumption that the directors and officers acted in accordance with their obligations. And this is because Delaware understands that the judge is not in a good place to second guess the judgment of business people operating in the market. You know, they're not here to be armchair quarterback after the fact. And they know that many times someone who makes a wrong decision still made a well-reasoned decision that should be respected. So oftentimes the business judgment rule looks at process rather than the outcome.
So they're going to look at the case as a whole and then go ahead and make a verdict on everything that's presented to them. And if they acted within the best interest of the entity itself, even though, like you said, it was perhaps a poor decision.
Mm-hmm. Yeah, to put in broad strokes, definitely. There's a lot of complexity in these cases, but generally the Delaware courts are hesitant to second guess business people who are operating under this constraints of oftentimes little time, deadlines. You know, they recognize that these people can do so much, and as long as they follow a proper process, disclosed all conflicts, and has taken steps to mitigate those conflicts, Delaware generally is loath to second guess those business people.
And that's why 67.8% of all Fortune 500 companies are incorporated in Delaware. 89% of all companies engaging in the IPO in 2019 were Delaware entities. I mean, some of these names, Uber, Lyft, Pinterest, Slack Technologies, all had IPOs. They're all Delaware entities. So you've got some strength there when it comes to name recognition for sure.
That's right, and that's both from a practical and an optics perspective. You know, the high net worth and institutional investors that back these companies that ultimately go public, and the investment banks that help them go public, prefer Delaware companies, both not only for the sophistication of Delaware's law, but also simply for the fact that they know Delaware law. They know how to predict and plan ahead of time how they can engage in a compliant transaction and a compliant IPO.
And we hear it quite a bit from clients that may have formed a company, for instance, in Colorado or California, and now they're looking to go ahead and bring on investors in the company and all of a sudden these investors are mandating that this transfers into a Delaware entity. So we've seen that many times throughout the years.
Definitely. There's a lot less certainty when dealing with other jurisdictions. There's a case in Nevada recently that is just seen as a complete debacle for their attempts to sort of catch up with Delaware as a business domicile. These judges who don't have the familiarity with business governance cases make these wildly odd decisions and come out with these wildly odd results in cases before them. And the investors are watching. The investment banks, the investors, and the brokers are all watching these things, and they prefer the certainty that Delaware law provides. I'd like to go into first at the sources of law governing corporations. So what bodies of law govern aspects of the corporate formation, existence, and business operations? First, you have the state law. You have the Delaware General Corporation Law. That's the key law that governs every aspect of a Delaware corporation's existence. You also have the state law of jurisdictions where the corporation does business. So if your office is in California, per se, even if you're a Delaware company, you may be subject to certain California requirements. For instance, California has come out with requirements that a certain number of women and persons of underrepresented communities be on the board. Eventually, that will go to be about 40% will have to be women or underrepresented communities. And even if you're not a California company, if you are doing business in California and have a place of business there, you have to abide by these requirements.
So even though it's a Delaware entity governed under the Delaware General Corporate Law structure, since the entity is actually physically operating in California and foreign qualified, meaning it's a Delaware entity formed in Delaware but physically operating in California, it foreign qualifies to operate there, it still has to follow through with a particular rule such as that, which boils back down to the state law of jurisdiction where it does the business.
There are limits to that, however. Still, the Delaware General Corporation Law is the governing law for these companies. However, there are certain laws that do apply to companies doing business, say, in California. Just as there are for, say, companies selling over the internet are subject to certain laws of all 50 states, like information security measures and things like that. But primarily what we're dealing with and what a corporation and its directors and officers will deal with is the Delaware General Corporation Law. Now, federal law will also affect the operations of a corporation. For instance, capital raising is governed by SEC regulations, laws administered by the SEC and the regulations they've adopted.
So the capital raising, the selling the shares of stock and bringing on investors, that's what you're referring to.
That's right. That is primarily all federal law. It's the Securities Exchange Act of the Securities Act of 1933 and the Securities Exchange Act of 1934. Much of the federal law, however, is only applicable to public companies. Once companies reach a certain size and begin, quote, reporting under the Securities Exchange Act of 1934, that's when you see a number of the substantive and reporting provisions of federal law applying. Similarly, you'll see stock exchange regulations applying to public companies that are traded on those exchanges. So there's a large body of overlapping different sources of law. But again, primarily, the law that's most important for Delaware corporations is the Delaware General Corporation Law, the DGCL, as we'll be referring to it here. Now, some will ask, what are the advantages of the corporate form? Why a corporation over an LLC? Well, we've talked about some of them.
And you think we're currently, last year, for instance, almost 73% of the new formations in Delaware were LLC. So why would you want to go with the corporation versus the LLC? The LLC is easy to operate, no minutes, meetings, bylaws. It doesn't have shares of stock.
The same things that make it easy to operate are in some ways the way that make it ill-suited for public companies. The DGCL provides a framework of law that limits the flexibility one has to vary the terms of the corporation. See, an LLC is a creature of contract. Essentially, you can have any terms that you want. You can amend or modify the fiduciary duties governing management. You can create an entirely new set of fiduciary duties. You can arrange your terms in an LLC in any way you want. But in some ways, that is difficult, particularly for a company that's looking to go public, because the DGCL creates certain bedrock rights and obligations that people can count on. They don't need to understand what the terms of every provision of an operating agreement says in an LLC. Instead, they know that there are certain parameters that a corporation cannot go outside of in how it structures itself and how it acts.
The checks and balances are there. You know what to expect more or less with the corporation when it comes to being a shareholder. You know what to expect from the officers, and also you know what's expected of the directors as well.
That's correct. And this limited flexibility, in fact, often is a benefit, because each LLC case, a judge has to look at an LLC as a contract, but each one is different. The wording is different. The terms are not uniform from one LLC to another quite often. Whereas a corporation, there are certain principles that apply regardless of how things are stated, how things are worded. There are certain bedrock portions of law that can't be wavered. See, for instance, fiduciary duties. You cannot waive certain aspects of the fiduciary duty in a corporation while you can in an LLC. There are certain terms you just cannot adopt in a corporation, because while the DGCL allows for some flexibility, it does not allow you to completely whole cloth throw out the statute as you can with an LLC, if you so choose.
So more or less the freedom of the contract, more or less, is not there with the corporation, so they have these rules to abide by.
That's right, and that gives comfort to some investors, particularly retail investors at the point where a company goes public. They're buying and selling shares of stock with certain understandings imposed by the DGCL. One of the other aspects of a corporation that make it both attractive and unattractive, depending on your perspective, is the default SCorp taxation. Now, a C corporation is not a type of corporation. It's simply a tax status. And it's the default tax status for a general corporation in Delaware and everywhere. It effectively means that it's double taxation.
And this is taxation from the IRS. So by default, this is going to be taxed by a C corporation unless additional applications are made with the IRS to change this taxation.
That's right. Unless you elect otherwise, the C Corp taxation is what you'll get. And that's effectively double taxation. The company will pay income tax, corporate income tax at about 21%, subject to any deductions or reductions. And then after the corporation pays its tax, the shareholders that receive distributions, which are generally referred to as dividends in a corporation, then must pay tax on those dividends, which can either be at their ordinary income rates or at 0%, 15%, or 20% for certain qualifying dividends where they're treated rather like capital gains.
Now, the C corporation or the C taxation, it doesn't limit who can invest within the company like other taxation methods might for the corporation.
That's right. The C corporation, the C Corp status really doesn't affect your operations, whereas the alternative, there is a pass-through option for corporations, or SCorp status, S corporation. In an S corporation, you're able to elect S corporation status, and it's much like the pass-through given to an LLC, though with certain small differences. Essentially, the shareholders will take into account the items of income, gain, or loss from the company, rather than the company paying taxes itself. However, this comes with a great deal of additional requirements. For an S corporation, for instance, you cannot have more than 100 shareholders. Your shareholders have to be individual natural persons rather than entities, except for the case of certain tax-exempt entities, trusts, and estates.
So your pool of potential investors is a lot less.
That's right. And an S-Corp is really much more meant for a closely held, family sort of business, rather than one that's a high-growth business, your traditional startup that's going to either go public or be sold, hopefully relatively quickly.
Now, the tax status is not necessarily written in stone. Entities can go ahead and change from C to S as needed.
That's right. It's important to note that the C Corp and S Corp are not types of corporations. Many people often refer to them as a different type, but really it's just a tax classification that you can elect. C corporations can become S corporations with some difficulty. S corporations can become C corporations much more easily because there's less constraint on your operations, your investors, things like that. Now we're going to go to sort of what are the bedrock features of corporations? What are some of the core elements of what a corporation is? You know, a corporation originally was referred to as a nexus of contracts with the government and with shareholders and with the entity itself. A corporation has legal personhood, meaning it can sue, it can be sued, it can hold assets, It can declare bankruptcy. It can do all of these things on its own behalf as if it were a person. And after the court case in Citizens United, corporate personhood took on a much more urgent nature, as we were able to say that corporations can now have rights to political spending like a person would. So truly, a corporation is a legal person in many respects. One of the key elements of a corporation is limited liability, meaning no person is liable for the debts or obligations of the corporation ordinarily. Now, there are two instances where this may not apply, and persons can be held liable for the debts and obligations of the company. For instance, a director who calls improper dividends, if the board calls improper dividends in a negligent or willful manner, they can be held personally liable for returning those distributions to the company. Similarly, there's a concept called piercing the corporate veil. Piercing is when the personhood of the company is essentially removed and the individual shareholders underneath, the owners of the corporation, become liable for its debts and obligations. That occurs primarily when corporate formalities are not respected. When, for instance, the bank account of the company is commingled with the money of other entities or some of the owners or even the founder, or where, for instance, minutes aren't kept, meetings aren't held, decisions aren't documented pursuant to resolutions. So that's one of the reasons that it is so important to mind the corporate formalities of calling meetings.
And these meetings and the formalities that you mentioned, the minutes, the meetings, the bylaws, these are all internal matters within the company itself. They're not filed with the state of Delaware, but it's crucial to keep them current and on file at all times in the company itself to not allow for the piercing of that corporate veil.
That's right. I mean, really, when piercing would come up is in litigation. When the company is sued, during discovery, the records and internal governance documentation will be requested by the plaintiff, and they'll be able to say, listen, this company is really just the alter ego of the owners. It's not being run as a separate entity with its own goals and objectives. Rather, it's really just a shell to effectively hide behind liability.
So it's important to have a business life and a personal life as well. If it's in the name of the company, it's done in the name of the corporation itself, and make sure not to commingle funds.
That's true. I mean, the assets of the corporation have to be truly the assets of the corporation. The bank account has to be inviolate. You can't take it out to pay for personal expenses. And as long as all that is met, then the liability of a shareholder is limited to the amount of his or her investment. The next item I'd like to discuss is the general management of a corporation. Corporate management is under the control and direction of the board of directors. Now, a corporation has to have at least one director, but there's no maximum number of directors set by the DGCL. As a practical matter, however, the larger the company, the larger the number of directors, particularly given that the board can operate through committees, smaller groups of directors that are responsible for certain decisions, certain areas of the company's life or oversight of the business. And the board may also include board observers. Many times an investor will have a board observer who may not have a vote, but is eligible to participate in the discussions. So the core concept here to remember is that corporate management is vested with the board. Now, the directors may, but need not be, officers or shareholders themselves.
So one person can be the entire company. We don't need to bring in outside individuals that you might not necessarily want there in the first place. So Jared could be the shareholder. Jared could be the only officer and the director as well. But if you'd like to, you could bring on another director or officer as well and still stay the only shareholder.
That's correct. Yes, directors don't have to have any other involvement with the company than being directors. And in many cases, it's wise to have a minority of independent directors. Independent directors are particularly useful when you're looking to effect a transaction in which other directors have a conflict. For instance, if I own company B and I want to enter into a contract with company A, of which I'm also a director, an independent director without that conflict could cleanse the transaction of any appearance of wrongdoing by signing off on it, him or herself. This is particularly important in public companies where conflicts have to be dealt with by independent directors. Exchange requirements and SEC regulations often require a certain number of independent directors in order to list a company or to keep a company public. And the Delaware General Corporate Law has often pointed to the action by independent directors as, again, cleansing a conflict and making a transaction that might otherwise be dubious have been properly authorized by the board. So the board delegates the day-to-day management to officers. Generally, an executive officer is necessary. A president, a CEO, and a secretary are necessary to take action and to record action, respectively. That's what most people start off with. You really have to have a president and a secretary. It's also very wise to have a treasurer, too, someone that handles the financial matters. And the reasons you have these different people, if you can, of course, you don't need to have them all, but it's so that, for instance, the secretary can sign off on the ability of the CEO to sign a document. You've got internal checks. You pass a resolution where the secretary has a certificate he signs saying, okay, the CEO has signatory authority over this, this, and this. And without those separate persons, you're really just passing paper from one hand to the other, which again is fine, but raises some issues. Now, the authority given to an officer is delineated generally in the bylaws. They may or may not have a separate employment agreement, which may describe the scope of their duties, but there need not be a separate employment agreement. And the officers may be, but need not be, either directors also or shareholders. Another feature of the officers' role is that they often become shareholders through their compensation. Oftentimes they'll receive a salary, but also equity compensation, whether in the form of restricted stock or options, warrants, or other forms of compensation through ownership that vests over time. Where
you don't necessarily need to have a salary for these officers. They could receive stock options, for instance.
That's right. And early in a startup's existence, oftentimes that is where the main compensation is. You're gambling on future success, essentially taking what might be worthless stock at the moment, but in the future, certainly, hopefully, it'll have a value.
So Jared, I know the next topic you're going to talk about is corporate taxation, and as you get into it, one of the questions that came in was somebody was asking about the potential benefits of changing from a C-Corp to an S-Corp. So I don't know if that'll tie into what you're talking about here, but just keep that in mind, and if there's something you can direct to as for an example of that, that would be
Sure. You know, we've talked fairly in depth already, well, for an overview of corporate taxation, and it's really difficult to say. It depends on the circumstances when it would be beneficial to shift from a C Corp to an S Corp. Generally, again, an S Corp is a smaller company where pass-through treatment makes sense. Oftentimes, you sort of have to look at the nature of the income that's coming in, the way the gains and losses are most efficiently allocated, and C Corp status is the predominant status for a company that intends for high growth, for moving forward. Whereas if you're running, a store, a mom and pop operation, an S Corp might be an option for you.
So if you're not looking to bring on different investors, if you're wanting to stay relatively tight-knit, if you're not going to be bringing on shareholders that are outside the U.S., if you were to consult with your tax professional, they might say, yeah, that S route, the S election might be the way to go for this particular situation.
Yes, it's very possible, but it very much does depend on the facts and circumstances of a given business, sort of what makes sense from a tax perspective for that entity, for its plans, and for its current situation versus what it intends in the future. So I think we've talked a great deal, as I mentioned, about the double taxation of corporations, where the corporate income tax rate of 21%, and then shareholders are taxed on dividends. Now, profit from the sale of shares, rather than distributions as dividends, are subject to either short-term or long-term capital gain tax. So there is a benefit in selling corporate shares after holding them for a year, where you get the long-term capital gains. If you sell them prior to that year, you will get short-term capital gains, which is fundamentally just ordinary income rates. So corporate taxation is something that's particularly facts and circumstances specific, and I recommend that people consult an accountant or at least an attorney familiar with corporate taxation and can really study their particular circumstances. Now, let's see, as a comparison to pass-through, we've talked a bit about the pass-through of LLC taxation. In an LLC, the income or loss flows through to the members, as does the character of the income to the LLC, capital gains, ordinary income, etc. And members take LLC items of loss and gain onto their own taxes. This is in contrast to the double taxation of corporations. But, like the SCorp is a similar form of pass-through, although, as you'll see here on my slide, there are quite a few restrictions that make the SCorp impracticable for many companies.
So, for instance, the taxation for an LLC is traditionally that of a partnership if there's more than two members, or if one person is taxed more or less, just like that of a sole proprietorship.
That's right.
Whereas the corporation offers that pass-through tax status. But one thing that is interesting as well is the LLC can go ahead and elect for that sub-Chapter S tax status with the IRS. Why would an LLC opt to go for that taxation?
You know, oddly enough, yes. The check-the-box requirements the IRS has for taxation now allow a great deal of flexibility in, for instance, a corporation electing pass-through treatment, an LLC electing, while a pass-through entity as a default, electing pass-through treatment under SCorp status. The SCorp status and LLC differentiation has to do with the extent to which the character of the income passes through. It's a bit outside of the scope of this discussion here, but there are some instances where an LLC may elect to be taxed as a corporation or taxed as an SCorp. Now, perhaps the best way, I think, at looking at some of the key elements of a corporation are to look at the main corporate documents and what do each of them generally contain and what can they contain. The key corporate governing documents are, one, the Certificate of Incorporation, or also known as the Charter, and the Bylaws.
Now, that Certificate of Incorporation, that's going to be the only document filed with Delaware Division of Corporation, Secretary of State's office. It's like the birth certificate of the company, or like you referred to it as the Charter. Mm-hmm. Whereas the Bylaws, they're kept on file in the company itself, not provided to the state, and not traditionally part of the public record for a corporation.
That's right. And the Certificate of Incorporation, as you said, is filed publicly and publicly available. It can contain very little information, or it can contain a great deal. It really depends on where the founders and the corporate board and director and officers really want to put those provisions, because the Certificate of Incorporation is more difficult to amend, and it is the chief governing document of the corporation. So if anything in the bylaws runs counter to the Certificate of Incorporation, the Certificate of Incorporation will govern. And any conflict between anything except the DGCL, the Certificate of Incorporation, will govern.
So if there needs to be changes to the Certificate of Incorporation, they're not written in stone. Things can always change. We can always file amendments to change something or to restate the Certificate of Incorporation to include whatever may come up in the future. I know a lot of clients, when initially forming the company, are going to have a lot of uncertainty. They're worried about perhaps doing something wrong, or, what about this name? Am I stuck with it? Oh, no, we can always go ahead and change the name by filing an amendment. And same goes with the bylaws. Those governing internal documents, the bylaws, can be updated, modified, changed as needed.
That's right. Yeah, the Certificate of Incorporation, many times a company as a startup will start off with a very basic Certificate of Incorporation. And that's what I'm going to be looking at today when I talk about the key terms that may be in that certificate. As they grow and develop and the company matures, it can certainly amend its certificate however it needs to. Generally, an amendment of the Certificate of Incorporation requires a resolution of the directors be passed recommending the change, and then that a majority of shareholders of each class of shares entitled to vote votes in favor of that amendment. Now, the certificate itself can contain provisions that affect how it itself can be amended. So, for instance, the certificate might say that each class of shares has to vote, a majority of each class has to vote in favor of the amendment, or it could say that all of the classes are treated as a single class for purposes of this vote. And therefore, each individual class doesn't need to have a majority in favor, but the overall body of shareholders has to be in favor, those at least able to vote. Now, even for in non-voting shares, certain amendments to the Certificate of Incorporation have to have the approval of even non-voting shares if it adversely affects them in certain specific ways. But yes, Certificate of Incorporation, the two things to Primarily remember there that it's publicly filed and that it can be amended. The bylaws are sort of the nuts and bolts of the corporation. They build upon what's in the certificate of incorporation and talk about the real details, the mechanics of how these things work, as we'll discuss in a moment. There are some other potential agreements that can govern the operations and internal workings of a corporation. For instance, the investor rights agreement often talks about what happens to a certain class of shares in the event of an initial public offering. What happens if the company wants to take certain actions? What veto rights do these specific class of shares have? So initially, a corporation's documentation can be very simple, but particularly as high net worth and sophisticated investors come in, they're going to demand certain rights, certain privileges, and certain powers. And those are often documented in either the investor rights agreement or the shareholder agreement. The shareholder agreement is actually an agreement among the shareholders where you can waive statutory rights by agreement. So it's the shareholders coming together outside of the corporation and saying, here's what we agree upon, here's what we're agreeing upon and how the corporation is going to be run. And so, for instance, the shareholders may agree that shareholder one will have the ability to appoint 2 directors out of 7, something like that. You come to these very specialized points, or how are we going to vote in the case of X event? It may have tag-along and drag-along rights, which is the rights of a majority shareholder to force a minority shareholder to sell, or inversely, a tag-along right is the right of a minority shareholder to tag along in the case the majority shareholder sells his shares. So that's really where the workings among shareholders are hashed out. But the key main documents for our purposes here are the certificate and the bylaws. The rest of them are much more complex and involve very specific situations and very specific negotiated terms. Now, the Certificate of Incorporation, as I said, the highest governing document, also referred to as the charter. And I'm literally just going to go down through here and go and look at sort of what the form that Delaware puts out requires. What are the basic elements that it requires? And I'm using these documents to illustrate the different points that come up in terms of corporate structuring and corporate governance. So, for instance, the corporate name even. The name requires a pre-formation search. Brett, I know you handle that quite a bit for...
Yeah, we can do the search within a matter of seconds, and it comes back with the results. We're able to search the Delaware Division of Corporations database. You can do that on our website quickly and easily, or live chat or call us.
And that's to prevent the same name from being used twice, if I'm correct.
That's correct. If the name's not available, if a client were to submit the filing on their own, it's going to get rejected. It's going to be wasted time, frustration. So yes, this is going to go ahead and clear the name and make sure it's available to be used within the state of Delaware.
Excellent. The second point raised in the Certificate of Incorporation is one has to list the resident agent, registered agent, and registered office. Now, we at Harvard are a registered agent, and we provide a registered office at our address. The registered agent effectively serves as the corporate locus in Delaware. It's the site that connects the company to Delaware if it doesn't otherwise have an office in the state.
And it's required by the state of Delaware.
That's right.
So the registered agent is going to accept the service of process, which hopefully the company doesn't receive. If there's any notices from the Division of Corporations, such as the annual franchise tax notice, which is traditionally the only tax paid to Delaware if not physically operating here, that's going to come to the agent, and we're going to forward that along immediately. If it does receive the service of process, our team's going to email and call and notify the company immediately so they can act on it. But it is a requirement. Our fee is $50 a year. It's guaranteed never to go up.
The next item in the Certificate of Incorporation is the corporate statement of purpose. Most people nowadays put in a general statement of purpose, usually something akin to any action or business that's permitted for a corporation under the DGCL. And the broad provision is certainly wise because you want to avoid what's called an ultra vires claim. Ultra vires simply means beyond the power. And if you have too specific, for instance, a business purpose, someone could claim that you've gone beyond the power of the corporation by entering into a different line of business. For instance, if you're a mining company and suddenly, and it states as much in your Certificate of Incorporation, suddenly you start opening retail stores selling clothing, investors or or even creditors might come and say, wait, this is outside of the powers of the company as stated. You stated the corporate purpose is mining, and now you're selling clothing. Now, that doesn't make the action invalid under Delaware law, but it does allow stockholders to bring a lawsuit against, in the company's name, against the directors and officers, or against the company itself as being outside of what the company can do. Now, the purpose statement is most important in the new form of public benefit corporation that Delaware has passed. And again, this is something I'm just touching on. We're going to do another webinar on public benefit corporations. But essentially, the purpose clause is most important in a public benefit corporation because there you have to list the public benefit purpose for which you're forming the company. So, for instance, this might be providing low-income students with high nutritional food in schools. Now, that would be in addition to the more broad statement of we are engaging in whatever business is legitimate for a corporation under the DGCL.
So for the PBC, the statement is more or less going to be stating it's public benefit that it's going to be going ahead and giving to society. So therefore, shareholders that are going to be investing within that public benefit corporation know that, hey, this is what the company's part of it is, its intended purpose is.
Yes, they know the social benefit that the company is seeking to provide. And, even there, it's important my recommendation and my practical point is always to include the general statement giving the broadest power to the company, and then including a second specific statement saying what the company's current anticipated plan is, one that's broad enough to encompass their intended operations, but not too broad so as to be meaningless.
And for the couple of people in our audience who have asked questions about the public benefit companies already, we will be touching on them a little bit more just at the end of this presentation. So I know there's a couple of questions that still need to be answered there. We'll get to those.
So next we're up to the initial shareholders of the directors. Neither the shareholder or the initial director needs to be listed or filed with the Division of Corporations. We tend to rarely see a client list a director's name on the certificate of incorporation filed to create the company. If we list a director's name, we also then have to provide the director's address. That's a requirement with the state of Delaware. And then any updates to that requires subsequent amendments, which are a couple $100 each time. So that's not something that we typically see clients include.
That's right. I mean, clients typically want to take advantage of the privacy that Delaware offers in having very little membership and operational information out there. I mean, of course, once you're a public company, you're filing giant reporting statements with the SEC and the exchanges. But until that point, while you're still privately held, Delaware very much respects the privacy of companies. The next item in the Certificate of Incorporation deals with share classes and par value. Now, par value is a largely outdated concept, but it's something that we do get questions about and something that is generally dealt with in the Certificate of Incorporation. Par value is usually a very small number, and it is a thousandth of a cent, and it is the lowest amount for which shares may be sold. In the past, it had much more meaning. Now, its only real purpose is for calculation of franchise tax. Brett deals quite a bit with the franchise tax, and it's a key element in calculating what you have to pay the state of Delaware.
We often see a par value for new startups. Maybe if they're going with 1,000 shares, it might be a penny. 10 million shares, we might see clients with 5 zeros and a 1, 0.000001 for the par value. Just really the amount, like Jared mentioned, that the stock can't be sold for less than. It can be sold for more or less whatever the market will bear, whatever someone's willing to pay.
That's right. And the next we're getting into the share classes now. So you have to set out what are the authorized shares and what are the different share classes initially. Authorized shares are the maximum number of shares that the corporation is authorized to issue. The share classes are of those authorized shares. How are the shares divided up? The key ways to divide shares are common versus preferred. Common shares generally have one vote per share. They generally intend to entitle the person to their pro rata share of the distributions based on the number of common shares held relative to all those outstanding. But you can create series of common shares with different rights and obligations.
So these different series, for instance, could have different voting rights. So a particular series could help keep control within the company and offer 10 votes, for every 1 share of stock that you own.
That's right. And there you start getting into more of a preferred concept. The common stock generally tends to be all the same common share. But the preferred stock especially will have different rights built into it. And there's myriad rights that can be built in here. I mean, there can be very complex rights that someone can negotiate for and can get from a company. And all of that will be built in to the certificate of incorporation and reflected in other documentation. The preferred stock may have different rights in terms of dividends. It may have preference in dividends, meaning it has to receive its dividends first before common stock receives dividends. It may have, as Brett mentioned, different voting rights. For instance, Facebook, Snap, many of those companies have a dual class structure where the founders and insiders may have 20 votes for every one vote held by a public shareholder. Preferred stock may have certain veto rights over key actions. It may have anti-dilution protection, meaning that if more stock is offered, the preferred stock holders have a right to purchase stock to effectively keep their percentage interest in the company, and all other types of preferences. I mean, really, preferred stock can vary in its terms in any way imaginable, subject to certain limitations, of course, under the DGCL that are mainly intuitive. What you will also see is blank check preferred stock, which is something I often include when I was in private practice. Blank check preferred is a class of preferred stock without any set terms. You would say that it's preferred series 1 stock, and then at a later date the board could set the terms of that series of stock and issue it. It essentially allows you to have stock in your pocket waiting to be issued such that you don't have to amend the certificate of incorporation. It gives the directors the ability to offer future investors another series of stock without the current shareholders having the ability to either approve or disapprove of an amendment offering a new preferred class.
So that's going to actually be listed on the certificate of incorporation. When the founders are creating the company, they're going ahead and mentioning the blank check preferred. So therefore, it's on the books, it's recorded, it's listed on the certificate. Everyone knows it's there.
That's right, and it would have to account for a portion of the authorized shares, total authorized shares.
So it's a powerful tool.
That's right. If you think of authorized shares as the ocean, the different subclasses are, buckets of water in there. You've got the authorized shares is the entirety of all shares, and the different classes, series, preferred, common, all of those are sub-portions of that authorized total. The next item we get into in terms of, on a related point in terms of shares, is whether shares are certificated or uncertificated. Now, this generally can be stated in the certificate of incorporation, but it need not be. If you're silent on the issue, then it's assumed that you're able to issue certificated or uncertificated shares. And now, what does certificated mean? It means, is a share represented by an actual piece of paper with the company's name on it and a whole bunch of other formalities and fancy drawings. In the past, certificated shares were very common. But when you think about the modern day, I mean, in trading shares, you would literally have to exchange pieces of paper, or your broker more likely would. With uncertificated shares, it's all done on digital ledgers. And one of the things Delaware has done is allowed and even encouraged uncertificated shares in order to allow you to trade shares through new technology, such as documenting the trades through blockchain. Uncertificated shares can be documented through a blockchain-enabled stock ledger that allows you to keep an immutable, efficient, and accurate record of your shareholders. One of the most difficult parts of just the processes of being a corporate secretary, for instance, is having these lost, damaged, mutilated, destroyed share certificates. How do you then reissue them? How much time is spent reissuing them? It's far easier to have uncertificated shares simply held in a ledger format. The next thing, we're getting down on time here, and I still have quite a bit to cover, unfortunately. I may only get through the certificate of incorporation. The next item is exculpation of directors. You'll often see in the certificate of incorporation, while it's optional, it's very common. You'll see a statement that a director will not be held for monetary liability for a violation of fiduciary duty. What that means essentially is while an overbroad statement, essentially the Delaware General Corporation Law allows you to remove monetary liability of directors for violations of the duty of care. So anything willful, criminal conduct is not included, and also any willful misconduct is not included. But in the sense that if someone is, for instance, negligent in their information gathering and making a decision, they didn't take in enough information or seek out enough to make an informed decision, a director can be removed from monetary liability for that omission. And most certificates will have that provision in there. You can alter the scope of it in the bylaws and later on and provide different conditions on the exculpation. But usually exculpation is the rule because it's management friendly, and above all, who's creating these companies but their management. And lastly, is indemnification. You often see indemnification in the certificate of formation, although it can be in the bylaws. Usually it's the mechanics that are in the bylaws, but the actual fact of indemnification is in the certificate of incorporation. Indemnification means that the company will pay the fees, expenses, costs, judgments, attorney's fees, any sort of cost or loss or other fee incurred in litigating or fighting a case brought against that person arising out of their action as a director or an officer. And certain indemnification is mandatory. If a director or officer is successful in the merits of his or her case, that's a mandatory indemnification. The company has to pay their legal fees and costs. Permissive indemnification comes in anything but a successful contest on the merits. So it is, oftentimes there are certain limitations on it. The boundaries, for instance, if he's successful in the merit, you have to indemnify that officer or director. But you cannot indemnify an officer or director if they act in bad faith or for a derivative suit brought by the company against that officer or director. But everything between that is permissive. You're allowed to pay someone's legal fees or judgments in really any way, so long as they were not acting in bad faith. Now, this is a cost to the company. So what does the company often do? Oftentimes it will go out and buy what's called D&O insurance. That effectively stands in and pays the legal costs, expenses, or other costs incurred by an officer or director that the company can't cover, either because of loss of assets or because it's not permitted under the Delaware General Corporate Law. I think,
Jared, actually, before you move on, there's a question that we just got that's relevant to what you're talking about with the certificate of incorporation. Somebody wants to know if there's no mention in the certificate of certificated or uncertificated shares, can it be regulated in the bylaws?
Yes, it most definitely can be put in the bylaws. Generally, silence on the matter in the certificate is treated as the company being able to issue either certificated or uncertificated, which would be stated at the time that the resolution is passed, issuing those shares. Okay. So yes, silence is permissive in that regard, but I do generally prefer to specify if I know they're going to be all uncertificated. I will say that out because there's no reason I see to justify certificated shares in this day and age.
Okay. And we have about 6 or 7 minutes left in the hour, and maybe we'll run a few minutes over, so just keep that in mind as you finish up.
The last thing I wanted to talk about on this point on indemnification is advancement. So the company is going to pay your legal fees, your costs, your judgments, your investigation costs. Well, that's all well and good, but they may be hundreds of thousands of dollars by the end of the action against you. And so how do you get that money? It doesn't help you if it's only after the fact. So a company will often advance those amounts to the officer or director as they're incurred. This is something that's permitted but not required. There's no right to be advanced your indemnification expenses for your judgments or costs. But it's very commonly done, and it's usually there is a required undertaking where the person must say they will pay back any amounts advanced to them if it's ultimately determined that they were not entitled to that amount. And so you say, okay, well, who decides whether you're entitled to indemnification or advancement? Oftentimes you link it to a judgment. You'll say, for instance, the person will only be not entitled to advancement if there's an adverse decision by a court of competent jurisdiction. So a judge says you acted in bad faith. Oftentimes, however, you can make the board, a committee of the board, or even a vote of the shareholders determine whether indemnification applies and whether advancement applies. Oftentimes, there'll be a separate contract as well. A director will require a separate contract where the company agrees contractually to indemnify that director. Now, why would you do that? Well, it gives you a contractual right as well as a right in the governing documents. Contractual rights can be more easily and more quickly asserted. And also, you can take what is previously permissive indemnification in the company's certificate and make it mandatory from a contractual standpoint. It gives the director a lot more comfort that after they have acted, that they're going to get the indemnification they were promised. Let's see, do we have any other questions at this point? I could launch into a much larger discussion, but I'm afraid I would keep us here for hours.
Well, Jared, why don't we...
I will just say, if I may, I wanted to get to the bylaws in here. But the bylaws are effectively the mechanics of the points we've discussed. The bylaws essentially discuss how are meetings called, how are director meetings called, how are shareholder meetings called, how are they conducted, how are the votes taken, what is the quorum for a board to actually effectively take action, what is the notice required before a meeting can be given. One of the key elements is can action be taken by written consent? So effectively in your corporation, if you allow written consent in the certificate of incorporation, you say shareholders may act by written consent, then instead of having to call a meeting, you can simply email, let's say 51% of the shareholders, say sign this consent, and the action is deemed taken, so long as you have the percentage of shareholders that would be required to take the action at a meeting. So this is a much faster, much easier way than having shareholders take action, than having to call an official meeting with 30 to 60 days notice, taking votes, accepting proxies. It can often be done in a day, and it's something that I've relied upon greatly in my practice to get things done very quickly in a corporation. The directors can also act by written consent where they don't need to have a meeting of directors. This means that if the directors unanimously agree on a certain topic, you can simply accept signed sheets saying that they agree on a given resolution, and that action is effectively taken. That's a key advantage that applies unless it's otherwise prohibited in the certificate of incorporation. So I like to say it expressly in the certificate, but you can do it so long as it's not expressly prohibited in that document.
Very good. All right. Well, Jared, we are running out of time, so let's wrap up your part of the presentation there. We're going to take some questions from the audience. I have some lined up, and if anyone listening has additional questions, please feel free to send them in. We'll answer whatever we can, and we'll hang around as long as there are questions coming in. I have a couple quick things I want to just touch on before we get there. So just another quick mention about us, Harvard Business Services. Jared and Brett are two great members of our team, and we have a whole crew here that is really dedicated to helping people form LLCs and corporations in the state of Delaware. And we've been doing this since 1981. We offer a very low cost to get that incorporation filed at $179. That's our green package, it's called. And it includes an entire year of registered agent service for Delaware. Again, we're a family-owned and operated company. We offer free lifetime customer support. We do offer express services if you need your company done right away. And I do encourage you to check out our reviews on Better Business Bureau and on Trustpilot if you want to see what some other people have said about working with us in the past.
I'd like to note, too, before we get too far down the road, that this is meant to be an initial webinar to cover some basics. And this is a kickoff for a podcast that Mike and I are going to be doing. Our first episode will come out September 1st, where we will be really drilling down into some corporate concepts that require more time for exploration, not just broad strokes. But for instance, I believe our first topic is going to be an overview of fiduciary duties, and then we will get into the sub-duties of duty to disclose, duty of oversight, corporate opportunities, things like that. So if you're interested in hearing more of a deep dive, more of a drilling down into these concepts, tune into us on September 1st for our first episode of our new corporate podcast.
Yeah, thanks for mentioning that, Jared. And actually, I'm going to send a link out in the chat right now for anybody who just wants to stay on an email list to be notified when that's available or coming up. Just go ahead, click that, enter your name and email, and all we're going to use that list for is just letting you know about the podcast that Jared and I are doing. All right, and then I think most of the people on our webinar today are probably already subscribed to our blog. If you're not, this is a nice, easy way to do it right on our website, DelawareInc.com. Just go to the blog, click on subscribe. You'll get these weekly emails with the latest news and information we have posted to our blog. We don't really send any other information. We don't sell your personal information or share it with anyone else. So it's really just if you want to stay in the loop with what's going on here and some of the happenings in the state of Delaware. All right, and with that, I think we're done with the content of the presentation. So let's jump into some of these questions that we have, and I know we have some good ones lined up. So, excuse me. Earlier, somebody had asked about when you're talking about par value, that they want to increase the shares of their company from 50 million to 100 million, but also increase the par value. So they were asking about how that would affect the tax, the franchise tax, essentially. So I know that can get a little bit complicated, but maybe Brett, you would want to address that.
When you go ahead and file the amendment to go ahead and increase the shares of stock, there's a formula that the state of Delaware uses. So a rule of thumb is the number of shares of stock multiplied by the par value. If it's less than 75,000, there's going to be no additional filing fees to go ahead and file the certificate of amendment, besides the state of Delaware's traditional filing fees. The franchise tax on a corporation with 50 million shares going to 100 million shares, they're going to get a franchise tax bill initially of $100 and some thousand, and they'll be required to go ahead and provide certain figures to recalculate that tax. And we've got a franchise tax team. They'll go ahead and work with you to ask about the gross assets of the company for that calendar year, and they'll ask about the number of issued shares. And once we have that information, we'll be able to go ahead and recalculate the tax. It's going to be a minimum of $400 franchise tax and a $50 report fee to the state of Delaware. So the least that you're going to be, least amount that you'll be able to pay is $450. It could be drastically higher depending upon the assets and issued shares of the company. But come franchise tax time, our team will work with them to ensure they're paying the least amount of taxes that the company is obligated to pay.
I highly recommend people go through the formula before they file a certificate of incorporation. One of the things I see lawyers do quite often is disregard par value and authorized shares, and then they hear about it when their client gets a tax bill at the end of the year from Delaware.
Right. All right, great.
It is a jaw dropper. A lot of times when the client gets the initial tax bill, the company's got no revenue, and the tax bill is $100,000, they tend to get quite ticked off. But once they go ahead and provide the gross assets and issued shares, it does drop down to $450, especially for new startups for the first couple of years.
I believe as a general rule, it's a good idea to limit your stock to what you actually need and not go above and beyond that. Is that
a lot of times clients want the ability to go ahead and have a lot of shares of stock to issue, so we often see 10 million shares of stock if they plan on bringing aboard investors quite aggressively. Others might start with 5,000 or less shares. 5,000 or less shares is going to be what we call a minimum stock company. With the annual report, it pays a flat $225 to Delaware. So we can always go ahead and amend that original certificate of incorporation to increase the shares to 10 million, to 50 million, to whatever's needed. But initially, it would help keep fees down for the franchise tax to go ahead and not have more than 5,000 shares.
Gotcha. All right. So we also, through the webinar, got a few questions about public benefit companies, which we didn't really have a chance to discuss in too much depth, but we can answer some questions now. So one person was just asking, does a public benefit corporation have to have stock? And if so, what's the bare minimum? And also, does it have to have a board of directors?
A public benefit corporation is really almost identical to your normal corporation except in two ways. First, it's allowed to consider other constituencies like workers, the environment, society, the well-being of the towns in which they operate, things like that, rather than just profit and maximization of the company to shareholders. Secondly, they have to issue certain reports as to how they're going after their purpose. Those are the two main differences. Otherwise, public benefit corporations are pretty much exactly like your standard corporation. They're run by a board of directors. They issue stock. It sounds like what the person is almost talking about is a non-stock corporation being used to form a nonprofit. Whereas a public benefit corporation is most definitely a for-profit entity. It just has these additional features.
Now, it could have one share of stock, and it could have one director as well. But yeah, it's exactly what you're saying. You might be looking more towards a non-stock, non-profit entity. Now, on the flip side, Delaware has enacted the legislation that allows for a public benefit LLC. So the LLC will not have shares of stock. It'll have ownership interest expressed within the LLC agreement. One person can act as the only member of the LLC. That's not something that we see done quite a bit, but it is something that we can help form as well.
The public benefit LLC is a bother to me because it fundamentally didn't need to be done. You could do everything that a public benefit LLC can do through a normal LLC operating agreement. It's simply a marketing technique to sign on and say, we care about this specific issue, but there's nothing it allows that couldn't be done otherwise in a normal LLC, which isn't the same for the corporation.
Right. And the two of you just answered the other question that we had in the queue about public benefits, which is that somebody has an LLC, a regular LLC, and is changing or is interested in changing to a public benefit. So I guess it is possible for an LLC to change to a public benefit corporation and not a public benefit LLC.
And to change to a public benefit, nothing's written in stone, so the sky's the limit as far as what they want to do. So the LLC has the ability to transfer into a public benefit LLC, or it could go ahead and change from the public benefit or from the traditional LLC and convert over into the public benefit corporation. So Delaware is going to allow for these entities to make any type of changes, more or less, that are fathomable. So it's something that can be done in just a couple business days. Now, in regards to any tax consequences, they might want to speak to their accountant, but yeah, it can definitely be done.
And also, the Delaware just passed, and I believe it's been signed into law now, new provisions that make it easier to switch from a public benefit entity to a standard LLC or corporation, and vice versa.
Very good. Sorry, I'm losing my voice. A couple people have asked, I just want to clarify, we are going to be sharing the PowerPoint slides in a PDF format tomorrow, as well as a recording of this entire webinar. So you don't have to worry about, frantically writing notes. If there's something that interests you, we'll be sending it all out tomorrow. Here's a good simple question. Can a business entity outside of the USA buy or hold shares of a Delaware SCorp?
Corporations can be owned more or less by anyone in the world. We have a lot of clients from all over the world that are setting up a Delaware entity that's being owned by their entity in their current jurisdiction. It's something that we do see.
The only thing that might preclude that is tax consequences for the individual, and they would need to talk to their own tax advisor on that point. There's certain tax provisions that deal with non-U.S. persons, non-U.S. entities buying shares in a U.S. corporation, but otherwise, certainly.
Great. All right, and we still have some questions coming in, so we're going to keep going here for a bit. Next one I have is it possible to request additional authorized shares and change the par value originally stated in a certificate of incorporation? If one does this, is there a way to avoid the founders from being diluted?
Yes, the answer to the first part, most definitely. You can change the authorized shares and the par value with a certificate of amendment. In terms of dilution, I would imagine you would make an issuance or a stock dividend or some sort of either stock dividend or a split or something that would prevent dilution of the founders, certainly. I mean, I don't know what stage that company's in, how many other investors, but certainly if you up the authorized shares and then issue more shares, certainly you'll have dilution if you don't somehow use a preemptive right or something to keep that percentage there. But simply also upping the authorized shares alone doesn't decrease the actual percentages of outstanding shares. So that won't be dilutive in itself.
Right. Okay, makes sense. Can the name of the incorporator on the certificate of incorporation be changed, and does it matter whose name is on the certificate as the incorporator?
I don't know why you would change it, simply because the incorporator, it's sort of a snapshot in time. It was when it was formed. It doesn't really matter after the formation at that point. They immediately resign their powers right after the formation normally. So I don't believe there's any issue there.
Okay. Very good. Next question is, do we need to wait for our EIN to be issued to have our first board of directors meeting, issue stock, and assign roles?
No, definitely not. Your EIN is not necessary to set up these internal governance type things to go ahead and now, if you're going to be paying anyone or have employees and you're going to be issuing paychecks, you'll need an EIN. But to simply document roles and set up the internal mechanisms of how the company will work, to have a board meeting, no, you don't need your EIN.
Okay. All right. Another question from that same participant. We just incorporated with 10 million shares at 0.00001 par value. We got the default common stock, which are yet to be assigned. However, I read it's good to have the founders assign themselves preferred stock early on. Is that correct? If yes, then should we issue preferred stock as well and assign it to the founders, which are this person being a founder?
To my mind, that depends on your plans. I mean, if you intend to go out there immediately and start raising capital, then you may want to protect your interests and your control with certain preferred stock. They'll often have a Class F stock for the founders that gives them certain voting rights or certain protective rights, anti-dilution rights. But it really depends on their plans going forward, whether they need those special rights, whether they're going out and selling stock, and whether they're not willing to take that dilution, things like that.
All right. Great. So we have one more question, and so if anybody else listening has a question that we have not already addressed, now would be the time to get it in. Otherwise, this will be the last one that we'll wrap up on, and it goes back to one of the questions we were discussing earlier. Person says, we just filed articles in Delaware for a client and used 1 million shares. Is there a way to amend that to a smaller amount so the client doesn't have to pay a huge tax to Delaware this year?
They'll need to work with our franchise tax team on that, because they're going to have to go and take into account the amount of time they had this much shares, the gross assets. So it's going to be a little tricky. Moving forward, it'll definitely help for the 2021 calendar year, but for this year, it's a startup, so the company probably is not going to have that high of a gross assets and issued shares, so it's probably not going to be much more than $450. Probably will be $450, but it could potentially be lower depending upon when they do the amendment. Our franchise tax team can be reached at the 800-345-2677 extension 6904, and they'll be able to go over exactly the type of franchise tax fees it'll face.
Brett, should they file a certificate of correction rather than a certificate of amendment at that point? The certificate of correction is when a mistake is made in the filing, and you simply go back and correct it as if the original had never occurred.
That's a great point. We see that. A lot of times client might have had a fat finger and put an extra zero for the amount of shares of stock it has to issue. And lo and behold, oh my goodness gracious, no, it's completely wrong. And that correction, like you said, allows it where it just never even happened and corrected that original filing. So it'll have a trail. It'll have its original certificate of incorporation along with the correction fixing that mistake on the original document. That's something to look into as well.
So there are a couple of options. If they do the amendment, then it's essentially prorated for when they did that amendment during the year, more or less.
The correction would be a lot less money.
Right.
Well, not a lot less, but it would be less money.
Okay, very good. We did have somebody ask a question just now. That is one of our most common questions that we get, and unfortunately we don't have the best answer for it. Is, do you help with setting up the bank accounts in the U.S. for non-residents? So, what are you usually telling people?
That's the hardest part, because now, especially with the COVID situation, the U.S. banks are going to meet with someone in person from the company with the certificate of incorporation, with the tax ID numbers. There's certain banks that I know, Jared, you've had relationships with, and has helped many of our other non-U.S. clients. Banks such as Mercury Bank is one that we've heard a lot here recently. Payoneer's another entity as well that's helped a lot of non-U.S. clients. Those are the two that come to mind that really have helped clients. TransferWise is another one as well to look into. Or any bank that they can find that suit their needs. We found that there's not a set standard when it comes to banking. Every bank can be a little bit different, but those are the ones to reach out to start that non-U.S. clients have had great success with.
Banks have the AML KYC requirements, which anti-money laundering / know your client requirements. And so non-U.S. persons trying to operate through a U.S. entity have it very hard getting bank accounts. There's very few banks that will work with them in an easy manner. I mean, oftentimes you may have to come to the U.S., you'll have to provide copious documentation, and banks often have standards that are even higher than what they're legally required to have. So even if it's a country that is not on sort of the Treasury Department's blacklist, like countries like Russia, Eastern Europe, a lot of African countries, South Asia, a lot of those countries banks look at with a little more they look a little more askance, and they have higher requirements for than your Western Europe,
You bring up a good point. Now, the bank account can be opened anywhere in the world. It doesn't necessarily have to be a U.S. bank account.
That's right.
That's one thing we do see. A lot of our non-U.S. clients are looking specifically for a U.S. bank account.
And it's very hard to
And that's the biggest hurdle that they're facing nowadays.
All right. And we've actually got some more questions still coming in. This is great. So let's keep going. And again, for anybody who budgeted 60 minutes for this, and we're now almost 20 minutes over, we are recording. So if you need to get a cup of coffee before your next meeting, go ahead and do that, and we'll have the recording to you tomorrow. Just to keep going, how do we record the changes in shareholders, especially early stage startup changing founders?
Well, in terms of recording the changes, what you would generally do is you would first look at any transfer restrictions you have in your documents. If the person is selling their shares and selling them to someone else, for instance, what you really need to maintain and what Delaware law provides for is a share ledger. We have encountered various automated systems that startups can use. There's companies out there like Carta that maintain these share ledgers that are very easy to update. They allow you to upload the documentation with them, so you have everything all in one spot. But for the earliest type of startup with just a few shareholders, you just create a spreadsheet sometimes,
right?
And you just enter in the sale price, purchase price information for tax purposes,
great,
and make an updated ledger.
And we do have a template for that on our website, and I just chatted out the link for that. It is in an image file, so you can't fill it in quite like a spreadsheet, but you can either use it for inspiration or you can print it out and write in it in pen if you need to do that. So that is.
And Delaware is one of the jurisdictions that's very aggressively promoting blockchain-enabled share ledgers, so that a ledger can be immutable, quickly updated. You can have certainty, it's fast, it's efficient, and again, everything is in one spot.
All right, and so to move to the next question here, you mentioned that you can file a correction and not an amendment. Is that only viable during the first year? And this is in reference again to to reducing the number of shares that were created with the company.
Changes can always be made. So, for instance, clients file certificates of amendment that have been incorrect. So we've seen them file corrections to an amendment, to a restated document. We had a guy recently who filed a change of registered agent and typed in his name wrong, wanted to get it corrected. So more or less any filing that's made can have a correction submitted to Delaware.
So there's not a statute of limitations, so to speak, on when that can be filed?
That's right. And a correction can be to any certificate. I mean, we've had clients ask us to file a filing that then they later come back and say, oh no, I entered something incorrectly, so we'd have to file a correction to the correction. Anything filed can be corrected with a certificate of correction, and then it's as if the original filing had never been made.
Okay. Brett, as a follow-up on the bank question, if somebody who is not in the U.S. has a U.S. Social Security number, does that make the process easier to open a bank account?
Perhaps it could, because a lot of our clients that have had a SSN in the past have been in the U.S., from school in the U.S. Perhaps they have a U.S. personal bank account. They'll often reach out to that particular bank that they already have an affiliation with and find out if they'll be able to help them. Some non-U.S. clients have worked with banks within their country that have U.S. branches. That's been an option in the past that we've seen. It's just tough to tell the playing field and the rules and regulations with the banking and what the banks are requiring consistently changes, and it's just impossible to keep up with.
Okay. So again, we're back to our last question, but again, if there's more that you have to ask, please go ahead and send them in. We'll stay here as long as you're asking. But right now, this is the last one, and I'm not sure that we can provide a good answer here, but let me ask anyway. Does it make sense to make a new U.S. SCorp the holding company and make a foreign company the subsidiary? Are there any tax implications? What do you recommend? The foreign company is 3 years old.
I would have to know what you're looking to accomplish, I think, for that one. I would have to, because there certainly are considerations for U.S. companies owning non-U.S. companies. There's controlled foreign corporation issues with tax. Now, it sounds like it's going to be a subsidiary there. So, yeah, I would need to know more to give a really good answer to that one but primarily the tax consequences and the objectives. I'd have to know sort of why do they want a U.S. holding company initially? Like what are the goals?
Right. Yeah. That's kind of what I figured, and this is the sort of thing that we would typically recommend that somebody speak to their attorney or accountant, their personal attorney or accountant about. Just someone who's very familiar with their personal situation, what they're looking to accomplish, like Jared said. All right, so that was our last question. No more came in. So thank everyone very much for their attendance and great questions that came in. We hope this provided a lot of information for you. And again, keep an eye out tomorrow for an email with the recording and the slides from today. Thank you, and thanks Jared and Brett for your presentation.
Thank you all. Take care all.